We have already completed 12 lectures, but till now we have not understood what is the meaning of term evidence. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Evidence Act, we were giving all focus on section 3, which is interpretation clause, and in that series this is mostly my last and 7th video where we are going to understand the term what is evidence. Now, when it comes to law of evidence, I am in no hurry. I want to discuss every single term, every single section in detail. So I am going little slow with giving clarification to all the aspects. Hope that helps. With that, I am taking you to the first slide. First thing first, let us try understand the term meaning of evidence under dictionary meaning, or the general meaning of evidence is the available body of facts or information indicating whether a belief or proposition is true or valid. Now it can be body of facts or any information, and what do they indicate? They will indicate whether a belief or proposition which is true or valid. That is what we are going to understand from those facts or information, and for all those facts and information we are calling it as evidence. In legal term, the simple meaning can be anything by which any alleged matters of fact is proved or disproved. What comes in front of the court? There will be certain amount of alleged matters. Now with the help of evidence, it will be either proved or disproved. That will be the simple legal meaning of term evidence. If you would like to elaborate it little further, you can also say an evidence is every type of proof which are legally presented at trial, which are allowed by the judge, which is intended to convince the judge of alleged facts material to the case. Now there are 5 important aspects in that definition. What are they? First part, it says it is every type of proof. What are the different types of proof? It can be oral proofs or documentary proofs, or we can also say oral evidence or documentary evidence. And then we have this particular factor which says which are legally presented at trial. Now we are understanding the meaning of evidence. It is the legal meaning of evidence. So these are legally presented at trial. And who is allowing them to present? The judge will allow them to present. And what is the intention of judge? Because judge want to get convinced on certain alleged facts. Okay, that is the intention of seeing evidence. And for what? For getting convinced on the alleged facts, whether they are true or not, whether they can be proved or disproved. For that it is seen. This is the legal meaning of term evidence. When we are discussing about the term evidence, we need to know the meaning of many different terms, for which I have already made 6 presentations in the interpretation clause. Now evidences are connected to court because these are presented in court. Now what is court? I have already presented as a first video in interpretation clause. Then it is connected to facts. What is the need of evidence? It is to prove a fact. When it comes to fact, again there is an independent video where we have discussed about the facts which can be sensed by 5 senses of a human. And then we have also discussed the psychological factor that is related to mind or consciousness. Then there is something called relevant facts which are connected to evidence, and on relevant fact also there is an independent video. Then we understood the term facts in issue which are very important for evidence, and on that also there is an independent video. And evidences can be in 2 types, by oral or documents, and there is an independent video on documents also. And then these evidences are helping in proving or disproving or be not proved. About this also there is a video. Now I cannot touch them again because it kills a lot of time. So you have to go through all of those presentation independently, which are interpretation clauses, very important terms. And without understanding these terms, we cannot understand the term evidence also. And with that, I am taking you to section 3 interpretation clause. What does it says about evidence in my next slide. You might be thinking that I have invested lot of time on my first slide itself while explaining the general meaning and legal meaning of evidence. Why did I do so? Because under Evidence Act, there is no clear definition on what is evidence. Yes, under section 3, there is an interpretation on the term evidence, but instead of discussing too much on the term evidence, it directly gets into two different types of evidences. They are the oral evidence and documentary evidence. What does section 3 say? It says, and I read, an evidence means and includes all statements which the court permits or requires to be made before it by witness in relation to matter of fact under enquiry. Such statements are called oral evidence. That is the first part. Now, what is an oral evidence? If statements are given with the permission of court or on the requirements of the court by any witness in front of the court in relation to the matter of facts which are in enquiry, those are called oral evidence. The second part says all document including electronic records produced for the inspection of the court, such statements are called documentary evidence. While discussing on documentary evidence, I have in detail along with the pictures shown what are the different types of the documents. Interpretation clause says it includes letters, figures and marks. Then we have understood all the written documents are the documentary evidence. Words printed are documentary evidence. The map or plan is a documentary evidence. Lithograph is also documentary evidence. An inscription on the metal or the stone is also considered as documentary evidence, and then the caricature is also a documentary evidence. This we have already discussed while discussing about the documentary evidence. Now all that we are learning from section 3, when we are discussing about the interpretation of evidence, we are understanding two major types of evidence, that is the oral evidence and the documentary evidence. One very important case law that you should refer while discussing about the term evidence is Kalyan Kumar Gogoi versus Ashutosh Agnihotri. Here, the Supreme Court of India held that the word evidence is used in common parlance in three different senses. Which are the three different senses where the term evidence stands in common parlance? The first one as equivalent to relevant, the second one as equivalent to proof, and the third one as equivalent to the material. These are the three different senses for which evidence stands in common parlance, being relevant, being as a proof, and being an equivalent to the material. Now, what happens with the help of being relevancy or being a proof or being a material? With the help of this or on the basis of this, the court comes to a conclusion about the existence or non-existence of disputed facts. That is what held by the Supreme Court. I hope that's very clear. I'll just read out what exactly Supreme Court held here. It says the word evidence is used in common parlance in three different senses. They are A as equivalent to relevant, B as equivalent to proof, and C as equivalent to the material, on the basis of which courts come to a conclusion about the existence or non-existence of disputed facts. That's all it held. With that, I am concluding this presentation. In my next presentation, I will briefly take you through on the different types of evidences. Now, I am not getting in detail when it comes to the different types of evidences because over a period of time with the travel that we are making with Evidence Act, section by section, we are going to discuss all of them. But just to help you guys, if there is any direct question on the different types of evidence, that video is going to help. I'm working on that. In my next presentation, you will see the same. Till then, thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.